Please be seated. The sitting is open. The court meets this morning to resume hearing the first round of oral argument of the Gambia. I now give the floor to Ms. Diem Hon Ho. You have the floor, madam.
Thank you. Mr. President, distinguished members of the court, from the presentations you heard yesterday, there can be no doubt that the Tatmada's clearance operations in Minji, Chatpen, Mangnu, and 4 other villages that Mr. Njai discussed were carried out with extreme brutality. The UN fact-finding mission reported that a similar and strikingly similar modus operandi was employed in at least 54 other Rohingya villages, and it concluded that the extreme brutality with which these operations were carried out across northern Rakhine State was a compelling indicator of Myanmar's genocidal intent. In its words, genocidal intent was evident in the Tatmada's extreme brutality during its attacks on the Rohingya. The court is now well aware of the underlying facts, so let us turn to the jurisprudence. It is beyond dispute that the brutality of an attack on a protected group constitutes evidence of genocidal intent. The court itself recognized in Croatia versus Serbia that genocidal intent can be inferred from, quote, the scale and allegedly systematic nature of the attacks. The fact that those attacks are said to have caused casualties and damage far in excess of what was justified by military necessity. The specific targeting of members of the protected group, and the nature, extent, and degree of the injuries caused to the protected population. The ICTY and the ICTR have also found genocidal intent based on the brutality of an attack, not only through the attack scale and those targeted by it, but also because of the extent and the degree of injury which the attack caused to its victims. Each of these hallmarks of brutality evidencing genocidal intent is present in this case. Myanmar's clearance operation is large-scale and systematic. It caused civilian casualties and destruction far beyond any military necessity. They targeted the most vulnerable members of the Rohingya group, and they were deliberate and extreme in their cruelty. I begin with the scale and systematic nature of the crimes against the Rohingya. The ICTR trial chamber in the Nadine Dabahazi case explained that an attack on several thousand members of an ethnic group is itself indicative of the requisite intent to destroy that group in whole or in part. Similarly, the trial chamber found in the Akayesu case that an attack on a massive scale indicated that the massacres were aimed at exterminating the group. Our case fits the description here. As Mr. Lowenstein explained yesterday, in 2 waves of the clearance operation, Myanmar mounted a systematic and large-scale attack against the Rohingya. The UN fact-finding mission concluded that while the exact number of casualties may never be known, the clearance operations that started on the 25th of August 2017 alone have directly resulted in more than 10,000 deaths, an estimate it considered to be conservative. The United States Department of State's report found that the attacks were extreme, large-scale, and widespread. 1 in 5 witnesses interviewed had seen a mass casualty event of killings or injuries with more than 100 victims. The Holocaust Memorial Museum also found that, quote, the Myanmar's army attacks against the Rohingya population were both widespread and systematic. I now turn to the second aspect of Myanmar's brutality, which evidences genocidal intent, casualties and destruction far beyond any military necessity. In Bosnia versus Serbia, the court recalled the ICTY's findings that the executions in Srebrenica systematically targeted Bosnian Muslim men of military age, regardless of whether they were civilians or soldiers, with no effort to distinguish between them. The ICTY treated this pattern of indiscriminate targeting as probative of the intent to destroy the Bosnian Muslims in Srebrenica, in whole or in part. This court accepted the same factor as an indicator that genocidal intent was present in the particular circumstances of Srebrenica. The Tatmadaw too systematically targeted civilians with no effort to distinguish between civilians and RSF fighters. You will recall this excerpt from the UN Fact-Finding Mission's 2018 report. There was not the least effort on their part, that is the Tatmadaw's part, to make any distinction between RSF fighters and civilians, or to specifically target a military objective or identify and repel an immediate threat. Everyone was a target, and no one was spared. Later today, Mr. Sulman will explain why Myanmar's clearance operations were not counter-terrorism operations. Myanmar consistently employed at least 4 methods of violence that reveal an intent to kill as many Rohingya civilians as possible. You already heard yesterday evidence of 3 of them: indiscriminate shootings, burnings to death, and targeted executions. There is ample evidence that these methods were repeated in multiple Rohingya villages, which will be included in the footnotes of the compte rendu. Mr. President, attacks on escape corridors is the 4th modus operandi consistently employed by the Tatmadaw. Even after forcing the Rohingya to the Bangladesh border, the Tatmadaw was not satisfied. They wanted the Rohingya dead. As the UN fact-finding mission determined, Tatmadaw soldiers shot at groups of Rohingya who were en route. At times, these attacks occurred in villages that were already burned, where fleeing Rohingya were seeking refuge on their journey. At other times, attacks took place in forested areas, or when Rohingya were forced into the open, for example, when crossing rivers. The Tatmadaw turned border crossing points with Bangladesh into killing fields, opening fire on enormous crowds of desperate Rohingyas. On one occasion, Myanmar Navy sank 4 boats full of refugees. A survivor recalled, "There were so many bodies and so much blood in the river. It looks like the river was bleeding." Where the Tatmadaw did not shoot fleeing civilians, it starved them. Along the Naf River bank, on the Myanmar side, soldiers cordoned off the Rohingya waiting to cross, denying them food and medical care and leaving them to die slowly from hunger and disease. Journalists Alex Crawford and Neville Lazarus of Sky News, who reached Dang Khali Saw in Mangdor Township, described in their witness statement hundreds of desperate Rohingya trapped on the beach, some stranded for weeks, others for months, begging for help, holding out their children, the elderly, the wounded. They learned that thousands more were pinned along that strip of sand. These methods of extreme brutality, which were repeatedly and consistently deployed by Myanmar, produce casualties far beyond any conceivable notion of military necessity. Taken together, they reveal a deliberate design to destroy the Rohingya as a group. Mr. President, I turn to the third marker of extreme brutality, indicative of genocidal intent: the deliberate targeting of the most vulnerable members of a protected group. I am speaking here of the wholesale slaughter of children, pregnant women, as well as the elderly, people who posed no conceivable threat. This abhorrent conduct served no military purpose, or indeed any non-genocidal purpose. The ICTR trial chamber in Aceh underscored that the targeting of newborn babies and pregnant women on grounds that the fetuses in their wombs were fathered by Tutsi men showed an intention to wipe out the Tutsi group in its entirety. Likewise, the ICTY found in Popovich that the killings of some children, elderly and infirm, alongside the systematic execution of men and boys, suggested an intent to destroy the group as a whole. The UN fact-finding mission observed that the Tatmadaw targeted the most vulnerable, including children, women, and the elderly. The US Department of State similarly reported that the military specifically targeted those who were not able to dodge the attacks, often women, children, and the elderly. As you heard yesterday, there is extensive evidence of targeting of the elderly and pregnant women. You can find additional evidence cited in the footnotes in the transcripts. Mr. Lowenstein will present later this morning the legal conclusions to be drawn especially from the Tatmadaw's systematic, widespread, and deliberate targeting of Rohingya children and infants. The fourth and final hallmark of genocidal brutality, Mr. President, is the extreme cruelty with which an attack is conducted. Cruelty betrays the perpetrator's animus towards the targeted group and a calculated intent to maximize suffering as a means to bring about the group's destruction. It also evidences the consequences of long-standing efforts to dehumanize the target group. As the ICTR chamber held in Kayishema, quote, the cruelty with which the attackers killed, wounded, and disfigured their victims indicates that the anti-Tutsi hate propaganda unleashed on Rwanda and the desired effect, namely the destruction of the Tutsi population. The evidence we have reviewed shows that the Tatmadaw set out to brutalize the Rohingya with maximum cruelty. Violence desired not just to kill, but to terrorize and dehumanize. As the UN fact-finding mission and others have laid bare, the atrocities were systematic and immense. People burned alive, often locked inside their homes before the houses were torched. Bodies slashed and mutilated with knives. Victims doused with petrol and set on fire. And young children and babies stabbed, beaten, cut to death in front of their parents. These already brutal killings were often accompanied by mutilation and dismemberment. In Ket Yopin, a witness recounted at least 20 bodies in a field, their flesh cut into pieces. A witness from Labadam, Butidang Township described how the military cut the little children's bodies into pieces. Yet another survivor from Khun Pien, Mountdall Township, watched soldiers seize a young man, cut his ears and nose, and slice his body with knives. Still in Kwandin village, Butidang Township, girls were abducted, their breasts and genitals cut, and they were beheaded. Witnesses described intestine pulled out and displayed, limbs, hands, and feet severed, eyes gouged out, even from children, men castrated, tongues and testes cut off. Survivors also described hundreds of body parts hanging from trees and heads floating in the river like footballs. A witness from Mandor Township described the scene. I saw people without hands, with intestines pulled out, spread across the village. They shoot people. If they don't die, the military uses cobra knives to cut them. If the intestines don't come out, they pull them out. Mr. President, members of the court, extreme brutality of this scale and of this nature is not incidental to counterterrorism. It is the point. It tells you what the perpetrators intend to do, to destroy the Rohingya group as such. I thank you for your kind attention. May I request, Mr. President, that you call to the podium Ms. Pasipanushka.
I thank Ms. Diem Phon Ho for her statement. I now invite Ms. Paspanoja to address the court. You have the floor, madam.
Good morning, Mr. President, members of the court. This case presents a stark and well-corroborated record of the sexual violence perpetrated by Myanmar security forces against the Rohingya. What I propose to do today is to focus on how this sexual violence evidences genocidal intent. In the first part, I will focus on the legal principles that link genocidal intent with sexual violence. In the second, I highlight the features that are particularly probative that are present in this case. The court is already familiar with the atrocious acts of sexual violence perpetrated by Myanmar security forces. I therefore address the facts in a relatively limited manner, just to make clear that the 5 features that are probative are present in this case. I begin with the legal principles. International law recognizes that rape and other forms of sexual violence can reveal a perpetrator's intent to destroy a protected group. This traces back to the first conviction of genocide in an international tribunal, the case Jean-Paul Akayesu. There, the International Criminal Tribunal for Rwanda elaborated the contours of genocidal intent and established for the first time and authoritatively that acts of sexual violence can constitute acts of genocide and reveal an evidence. Sexual violence can reveal an evidence the specific intent to destroy a protected group. The ICTR found that the rape of Tutsi women was systematic and perpetrated solely against them. And in a formulation that has since become a touchstone, it held that, quote, sexual violence was a step in the destruction of the Tutsi group, destruction of the spirit, of the will to live, and of life itself. These determinations underscore 2 propositions central to the present case. First, that patterns of sexual violence are probative of genocidal intent when situated in a broader context of attacks upon a protected group. And second, that sexual violence may itself, by the means by which perpetrators carry out the destruction, constitute genocide. 3 provisions of the Convention are particularly important here. Article 2B, encompassing the infliction of serious bodily and mental harm. Article 2C, addressing conditions of life calculated to bring about physical destruction. And Article 2D, concerning measures intended to prevent births within the group. International courts have recognized that sexual violence can satisfy each provision, and that the manner and circumstances of its commission can reveal destructive purpose. The Akayesu trial chamber explained that sexual violence, quote, formed an integral part of the process of destruction because of the physical and psychological harms to victims, and the far-reaching effects on families and communities. In the ICTY, the Ptolemy Appeals Chamber emphasized that the manner and circumstances of the violence are relevant for proving specific intent. This court, in Croatia v. Serbia, recognized that both physical and mental measures can constitute measures intended to prevent births, and that conditions of life calculated to bring about destruction may be shown by patterns that degrade bodily integrity, reproductive capacity, and social cohesion. Akayesu and his progeny help us identify 5 patterns of sexual violence that are particularly probative of genocidal intent. The first is raping of women while killing their children. Such acts extinguish a group's present and future in the same moment and have been treated as emblematic of its destructive purpose. The second is rape accompanied by threats to kill or by killing, revealing an intent to destroy rather than merely to terrorize. The third is public and humiliating violence, mass gang rapes staged before family and neighbors in schools, mosques, or open areas, designed to degrade the group as a whole. The fourth is the deliberate targeting of women and girls of reproductive age, including pregnant women, with assaults aimed at reproductive organs and the abdomen, causing miscarriage, sterility, and trauma that deters marriage and procreation. The fifth is scarring, such as distinctive bite marks that brand survivors, fracture social bonds, and cause enduring mental harm. The evidentiary record supports the finding that all of these 5 patterns of sexual violence probative of genocidal intent are observable in the present case. First, Myanmar security forces routinely coupled the rape of women with the killing of their children. The UN fact-finding mission found that mothers were often gang raped while their babies and young children were beaten, stabbed, cut, shot, or killed in front of them. Many women described the loss of children or unborn children as the, quote, most unbearable aspect of the suffering resulting from those assaults. My colleagues and I addressed numerous examples of rape fused with killing of children in our presentations on 7 main villages yesterday. This pattern recurs across several other locations. For example, in Gayant Chang, in Ye Kat Chang Guason, and in Kiet Yopin. The US Department of State's randomized survey of 1,000 Rohingya refugees in Bangladesh likewise recorded multiple accounts of children beheaded or otherwise killed while their mothers were raped. These methods are incompatible with any benign explanation. They reveal a deliberate strike at both the group's physical existence and its biological continuity, squarely engaging Articles 2B, 2C, and 2D. Second, the Tatmadaw often explicitly declared an intent to kill their victims while raping them. On Monday, Mr. Suleiman provided several examples. And consistent with this hallmark, many victims were in fact killed after being subjected to sexual violence. Examples were shared yesterday. This pattern repeats itself in Yekat Changguason, Bahut Chang, and many other villages. Moreover, Tatmadaw soldiers testified that commanders ordered rapes that were accompanied by killing. One describing the clearance operations carried out by his unit in Mangdao and Butidang explained that, quote, when we clear house by house, there were rapes when we clear, and admitted that some of the women were killed after rape. Another soldier testified about sexual violence he witnessed in Taung Bazaar, confirming that troops were, quote, ordered to rape women, and describing how soldiers, quote, put the gun at the victim's forehead and killed right away after raping them. Rape followed by killing reveal an obvious intent to destroy. Third, Myanmar security forces conducted sexual violence in public and in particularly humiliating and brutal ways. The mission identified mass gang rape as a, quote, notable pattern with incidents in which up to 40 women and girls were raped or gang raped together. Assaults were in open areas, in large houses, in schools and mosques, in forests, in military and police compounds. Frequently, rapes occurred in front of family members, including husbands, parents, and young children. The mission reports that a, quote, total of 80% of incidents of rape corroborated by the mission were of gang rape, and 82% of those gang rapes were perpetrated by the Tatmadaw. Incidents of rape and sexual violence were also carried out by members of the BGP and the Myanmar police force and ethnic Rakhine, although considerably less so. Beyond the 7 villages addressed yesterday, public and humiliating gang rapes were perpetrated throughout northern Rakhine, including in Kiet Yopin, in Quint Pyu Chang, and in Maung Gin Hanut, as well as in Gayant Chang. Fourth, military forces regularly targeted women and girls of reproductive age, including pregnant women, inflicting reproductive injury. We addressed numerous examples yesterday, and others are recorded in Kien Chau, in Ga Sang Kyu, in Yu Sheka, and in Ka Mang Sek. The UN fact-finding mission and medical organizations recorded mutilations and other injuries to reproductive organs, miscarriages, prolonged genital bleeding, permanent damage requiring surgery. Survivors reported an inability to resume sexual relations or bear children, and widespread fear of marital rejection and social stigma. These are precisely the physical and mental measures the jurisprudence recognizes as measures intended to prevent births under Article 2D. Fifth, the Tatmadaw routinely sought to visibly scar and brand rape victims. The UN fact-finding mission and medical professionals recorded distinctive bite marks on the cheeks, breasts, and thighs, and mutilations leaving permanent scars. Forensic analysis confirmed violent bite marks on the face of a 15-year-old survivor and found that a, quote, substantial portion of women and girls had been bitten, indicating an intentional practice akin to branding. These findings are probative of serious bodily and mental harm and of the purposeful creation of social stigma that deters marriage and childbearing, falling within the mental measures embraced by Article 2D. Across these indicative features, multiple methodologically distinct sources converge with the UN fact-finding mission. The UN Office of the High Commissioner for Human Rights reported that more than half of women fleeing the 2016 and 2017 operations that it independently interviewed were victims of social violence and documented genital stabbing and other mutilations consistent with, quote, rape to death. The US Department of State likewise confirmed, based on its randomized survey, that Rohingya women and girls were subject to, quote, widespread sexual assault and rape during both waves of clearing operations. Respondents similarly reported, quote, exceptionally violent attacks during the rapes, and several individuals from different villages witnessed soldiers cutting off the breasts of women they raped and mutilating genitals and other parts of bodies. Mr. President, Myanmar's security forces' crimes of sexual violence against Rohingya women and girls achieved their intentions, the destruction of group life. The fact-finding mission concluded that survivors of sexual violence are less likely to procreate, less likely to marry due to stigma and ostracism, and in some cases, rejected by spouses. It described the broader social damage to the Rohingya's community, their capacity to live, to heal, and to reproduce. A multidisciplinary study published by Legal Action Worldwide in 2023 documented permanent genital damage affecting fertility and severe psychological injuries that have left survivors in extreme distress nearly 6 years after the clearance operations. That research found that the systematic nature of the sexual violence damaged the Rohingya social fabric in 3 mutually reinforcing ways. The ostracism of female survivors undermined cultural identity. The powerlessness of men to protect them eroded their social role, and the forced reorganization of family units and lineage weakened future social alliances, including marriage within the community. In short, the architecture of Rohingya social life was intentionally weakened, with consequences that endure and compound. These are physical and mental consequences contemplated by Articles 2B, 2C, and 2D. Taken together, these facts form the kind of pattern from which courts infer genocidal intent, as Akayesu and subsequent jurisprudence confirm. Before concluding, I address briefly Myanmar's contention that accounts of sexual violence should be discounted because they do not account for ARSA attacks. Even if, contrary to the evidence, Myanmar were to substantiate its claims concerning the ARSA threat in every village that suffered clearance operations and sexual violence, counter-terrorism operations do not justify rape, gang rape, genital mutilation, or the killing of children during sexual assaults. As Germany, France, Canada, Denmark, the Netherlands, and the United Kingdom observe in their joint declaration of intervention, I quote, "Sexual and gender-based violence is not capable of advancing any military objective. When it is pervasive, methodical, and directed at a protected group, it can provide compelling evidence of specific intent to destroy a protected group." Members of the court, the sexual violence inflicted on Rohingya women and girls was purposely destructive of the Rohingyas' physical integrity, reproductive capacity, and social cohesion. Its methods are hallmarks of a campaign to destroy a group in part. They satisfy Articles 2B, 2C, and 2D, and reveal the specific intent that the Convention requires. Sexual violence of the scale, character, and methods serves no military end. It is an instrument of destruction. I thank you for your attention and respectfully request that Mr. Lowenstein be called to the podium to continue the Gambia submissions.
I thank Ms. Paspanodia for her statement. I now call Mr. Andrew Lowenstein to the podium. You have the floor, sir.
Mr. President, members of the court, good morning. I will address children. The Gambia has chosen to make children the focus of this presentation because children are central to the crime of genocide. The 1948 Convention is fundamentally about the protection of human groups. And if a group is to continue, if it is to survive, it will be through its children. Raphael Lemkin understood this. That is why he addressed children and matters of birth in Chapter 9 of Axis Rule. The drafters of the 1948 Convention understood the centrality of children to genocide as well. That is why 2 of the actus reus of genocide set out in Article 2 are specific to children, imposing measures intended to prevent births within the group and forcibly transferring children of the group to another group, under paragraphs D and E. And of course, children can be and are victims of the acts of genocide described in paragraphs C, A, B, and C. The Gambia agrees with the interveners who have rightly placed significant emphasis on children. It agrees entirely with the submission of Ireland, which stated as follows: where there is evidence that children of the protected group have been particularly targeted, or that the conduct targeting the group made no distinction between child and adult members of it, certain conclusions can be drawn. as children are essential to the continued existence of any human group, acts constituting the material elements of genocide directed at or without making distinction for child members of the group will have an obviously significantly greater impact on the resilience and ultimate survival of the group than the same acts directed at a similar or larger number of adult members. It therefore follows that certain reasonable inferences can be drawn from acts directed against or failing to distinguish child members of the group. Mr. President, Myanmar killed the children of the Rohingya group, often in unimaginably cruel ways. The evidence is overwhelming. The horrors go on and on and on. Yesterday, during the Gambia's presentations on just 7 of the hundreds of Rohingya villages that have been the subject of these proceedings, you heard a fraction of it. You heard accounts like those which caused the OHCHR to report that victims who ranged in ages from newborns to teenagers included children who were killed by live ammunition or stabbed while at home, while fleeing to safety, or while in farms or fields. You heard testimonies matching those which caused the UN Special Rapporteur to report young children being thrown into fires. And you heard a great many examples of the targeted killings and other abuses of Rohingya children, like those underpinning the UN fact-finding mission's conclusion that children were subjected to serious human rights violations, including killing, maiming, and sexual violence. We will not belabor the point. Suffice to say, we could review with you even more evidence that is equally credible and terrible, both in relation to the villages discussed yesterday and many, many more. But we feel the point has been adequately made. It is, we say, incontestable that Myanmar did in fact systematically murder the children of the Rohingya group. It did so intentionally, it did so knowingly, it did so deliberately, and it did so on a scale that is or ought to be unimaginable. Therefore, unlike the presentations yesterday, the focus of my presentation is not evidential. Instead, I will address the legal significance of the evidence before you, particularly as it relates to the killings and other grave abuses to which Myanmar subjected Rohingya children. Where appropriate, I will refer to the evidence in order to discuss how it bears upon the legal determinations that you are called upon to make. However, the evidence per se will not be my focus. I begin with the actus reus of genocide, and in particular, killing members of the group under Article 2, Paragraph A. Myanmar argues that Article 2, Paragraph A does not apply to the legitimate killing of insurgents or terrorists in battle, in an armed conflict, or in a law enforcement operation, and does not extend to civilian deaths caused by such operations if they are exclusively directed at legitimate targets and the civilian casualties are not caused deliberately. Myanmar's intentional killing of Rohingya children in the circumstances and in the manner we heard yesterday bears directly on this defense. Its targeted killings of the youngest of the Rohingya group, including those not yet born, lacked any conceivable legitimate objective, military or otherwise. They were not carried out in the context of military or law enforcement operations. They were not directed at combatants. Instead, they were directed at the Rohingyas most helpless. Put simply, they foreclose Myanmar from being able to argue with any credibility whatsoever that Rohingya deaths were, in the words Myanmar used in the 7th paragraph of its rejoinder, that they were just collateral casualties of fighting between the Myanmar security forces and ARSA. That is false, manifestly so. And the same is true with respect to any similar argument in regard to the causing of serious bodily or mental harm within the meaning of Article 2, Paragraph B of the Convention. Mr. President, the targeting of Rohingya children has particular relevance for the Court's consideration of Article 2B, as it held in Croatia v. Serbia, for harm to be serious for purposes of that paragraph. It must be such as to contribute to the physical or biological destruction of the group, or in whole or in part. The Court's consideration of whether an act contributes to the physical or biological destruction of a group requires taking into account not just the nature of the relevant act itself, but also the specific circumstances of the victims. This applies with special force in relation to crimes committed against children, as happened here, in view of their heightened vulnerability. And the same is the case with respect to the deliberate infliction of conditions of life calculated to bring about its physical destruction in whole or in part under Article 2C. The acts that will qualify as the actus reus of genocide under this paragraph must necessarily take account of the particular characteristics of the members of the group that are impacted by the relevant conditions. Here, Rohingya children of all ages, including infants and newborns, were subjected not only to Myanmar's efforts to deprive the Rohingya of food and health care prior to the clearance operations, but also to the atrocious attacks on their villages and during their forced displacement, where they lacked food and shelter. I need not dwell upon the fact that children are especially vulnerable to such privations. Mr. President, this brings me to the issue of genocidal intent. Here, we respectfully submit the targeting of Rohingya children is of singular importance. The acts described yesterday qualify as acts of extreme brutality, one of the indicators of genocidal intent, as has been clearly shown by my colleague, Ms. Ho. So too, the fact that they were frequently committed in conjunction with acts of sexual violence, another indicator of genocidal intent, as explained by Ms. Paspinocha. But that is not their only relevance to genocidal intent. Myanmar's targeting of Rohingya children demonstrates that the members of the group were targeted because of their membership in the group. There is no other conceivable explanation. And the evidence that they were targeted on a significant scale, as is unquestionably the case, precludes any basis for concluding they were targeted for any other reason. Further, what qualifies as a substantial part of the group depends on the relevant circumstances, including whether a specific part of the group is emblematic of the overall group or is essential to its survival, as the ICTY Appeals Chamber held in Kursich. In that connection, Rohingya children form a substantial part of the Rohingya group, and thus their targeting is compelling evidence of Myanmar's intention to destroy the group as such, at least in part. That is undoubtedly so, as the physical destruction of the Rohingya as a group would be assured if the next generation were destroyed, as Myanmar sought to do when it systematically shot, stabbed, burned, and drowned Rohingya children of all ages. The targeting of Rohingya children is also highly probative of planning and organization, another indicator of genocidal intent. Mr. President, as you heard, Myanmar's targeting of Rohingya children was not confined to isolated incidents. They were a ubiquitous occurrence during the clearance operations. Médecins Sans Frontières estimates that between 734 and 2,109 children died during the clearance operations or were killed during flight to Bangladesh. And those are just the children under the age of 5. The Tatmadaw deliberately killed children in each of the villages that was addressed yesterday, and it did so in a great many more. These atrocities were committed in different geographical areas and by different military units, all subject to a common command structure. It is fair to say that the killing of Rohingya children is one of the clearance operations' hallmarks. In these circumstances, it is impossible to avoid the conclusion that this was planned and directed from above. Mr. President, this brings me to 3 more indicators of genocidal intent and their relation to the Rohingya children. The vicious race-based discrimination to which the Rohingya are subject, and Myanmar's propagation of extreme anti-Rohingya hate speech and its toleration for such public expression by others. Ms. Paspinocha and Mr. Suleiman reviewed the relevant evidence on Monday. What they described shines a revealing light on the question of how such widespread depravity could be perpetrated. It is not a coincidence that the Tatmadaw soldiers who committed such heinous crimes against the youngest of the Rohingya, even Rohingya who had yet to be born, in Mingi, in Chapin, in Mangnu, and in many other Rohingya villages across northern Rakhine State, and who wrenched infants from their mother's arms and flung them into flames, had long been subjected to the calumny that those Rohingya children's mere birth was a threat of the highest order. That message had been communicated by the Tatmadaw's leadership and its allies through their incessant propaganda about the exploding birth rates and about Bengalis spreading like weeds. The message was received. The message was understood. And when the Tatmadaw arrived at Mingi, at Chapin, at Mangnu, and at a host of other Rohingya villages, it was tragically, obscenely implemented. Mr. President, the bottom line is that the intentional, deliberate killing of Rohingya children on a scale as massive as happened here is irrefutable proof of Myanmar's specific intent to destroy the Rohingya as a group as such. It can only be understood as reflecting that intention. It is, put simply, an indicator of genocidal intent par excellence. As the ICTR found in Akayestu, evidence that even newborn babies were not spared reflected an intention to wipe out the Tutsi group in its entirety. That is true for the Rohingya as well. The killing of Rohingya children shows that members of the Rohingya group were targeted because they were Rohingya. In the words of Akayesu, Myanmar did this to wipe out the Rohingya as a group. Mr. President, thank you for your kind attention. I ask that you invite Ms. Alamin to the podium.
I thank Mr. Lowenstein for his statement. J'invite maintenant Madame Yasmin Alamin. Let me now give the floor to Ms. Yasmin Alamin. You have the floor, Madam.
Mr. President, members of the court, it's a great honor for me to address the court for the very first time here today, and to do so on behalf of Gambia and to support the Rohingya people. I shall address the issue of destruction and concealment of evidence of the crimes committed by Myanmar against the Rohingya, which also reveal the genocidal intent of the state. Honourable judges, such destruction and concealment was neither random nor marginal, but it was in fact the result of a coordinated policy whose effect and apparent purpose was to erase the crime by erasing its traces. The destruction and concealment of evidence betrays, in so doing, the genocidal intent of Myanmar. This destruction extends and consolidates the genocide. The UN reports, the geospatial analysis, and many testimonies establish and show that many Rohingya villages were methodically destroyed and that religious and funerary sites were razed to the ground, after which security bases and infrastructure were built on in these very places. Myanmar, therefore, intended to conceal its acts of genocide and prevent any in situ investigation. In so doing, Myanmar consolidated the fruits of its genocide by removing any trace of Rohingya presence in the martyred villages. In this context, I shall make four key assertions. One, it is factually established that Myanmar systematically destroyed, altered, and concealed evidence of the genocide against the Rohingya, as committed during the clearance operations of 2016 to 2018. Two, it went on doing so after the clearance operations to perfect the crime. Three, Myanmar systematically opposed independent investigation and access to its territory. And four, Myanmar's denial of the destruction of evidence is baseless. Let me start with acts as committed during the clearance operations. As my colleagues have said, between 2016 and 2018, clearing operations in the townships of Mongdo, Butidong and Ratadong were marked by a deliberate policy of destruction of the Rohingya people. At the same time as unprecedented violence was being visited on members of the Rohingya group, Myanmar tried to remove any trace of its crime and any trace of the presence of the murdered Rohingya. One of the main ways to do so was to dispose of the bodies in mass graves or to burn them. In Gudapin, in Butidong Township, for instance, the mission indicated, and I quote,
and the ethnic Rakhine men to dispose of bodies. A series of pits were dug in different locations and the bodies put in them. Quelques jours après les opérations,
a few days after these clearance operations, returning villagers identified and mentioned burnt bodies in shallow, uncovered graves. And the video reviewed by the mission shows human heads in a state of decomposition. The same was true in other villages. These observations are also corroborated by the statement of witness MS, which you will hear next week, and he testified that in Mingi, in Tulatoli, in Rohingya, and I quote,
after people had been killed, the military and Rakhine collected all the dead bodies like timber. and put them all together in 4 big holes, which some of them had dug. Some people were still alive at that point, but they were very severely injured, and the military and Rakhine dragged their bodies and put them in the fire. Then they brought some grass from the village and put it on the dead bodies. Then they put petrol or kerosene, I don't know which it was. I saw them pour something from the bottle and set light to these holes full of bodies. Some of the small children died from the initial shooting or being attacked by knives, but most were later thrown on the fire in the graves that were dug.
You have heard of similar or even worse atrocities in my colleagues' statements. It is therefore not surprising that the fact-finding mission came to the following conclusion.
The information points to a concerted effort by the Tatmadaw to dispose of Rohingya corpses following the clearance operations in villages. The manner in which the bodies were disposed of, including through the preparation of large pits, both to burn bodies and to bury them, suggests both a level of pre-planning and an intention to destroy criminal evidence. It is likely that hundreds and possibly thousands of bodies have been burned, buried, or subsequently destroyed. La mission d'établissement.
The fact-finding mission and other independent sources have also observed the mutilation and concealment of bodies, thus preventing their identification and the gathering of forensic evidence. A report by Associated Press documented through time-stamped videos taken on mobile phones and on satellite imagery and interviews at least 5 mass graves of Rohingya civilians in Gudapin. They also showed that the bodies had been burnt with acid in a clear attempt to destroy evidence. Soldiers brought large acid containers, used them to burn away the hands and faces. Public videos show puddles of acid around corroded bodies, as you can see in the public report that you will find under tab 6 of your binders. According to the UN mission, these macabre practices, which were planified methodically and methodically implemented, aimed at destroying any evidence of the crimes committed against these victims. Mr. President, ladies and gentlemen of the court, these damning facts are nothing random. They required a specific organization and logistics, something the armed forces had at its disposal. They were in fact confirmed also by the confessions of members of the Tatmadaw, which mention explicit orders to burn Rohingya villages and to remove incriminating evidence. Mo Yang Ning, a police captain that deserted, stated to Reuters that even though ARSA conducted no attack after 25th of August 2017, his superiors instructed him and other officers to burn down the villages strewn with many bodies following the clearance operations. Similarly, Captain Naim Yotet, also a deserter, indicated that the highest military judge in the country, Aung Ling Dwe, went to northern Rakhine State in 2017 to help conceal the evidence of the atrocities committed against Rohingya.
Number 4 Border Guard Force office in Maurawadi fabricated incidents as the military wanted and got rid of the evidence of the acts of terrorism that the military committed. Un des propres témoins du
A witness for Myanmar, in fact, confirms this practice. Captain Hain, in its statement under Annex 157 of the Counter Memorial, said that there had been burnings of bodies next to Betdaga village where the bodies were burnt and buried. This practice, however, appears nowhere in the rules of engagement of Myanmar, are not consistent with the Muslim funerary rites, and goes against the rules under the Geneva Convention. Other testimonies from soldiers also show that they were instructed to remove pictures from their phone and that deception was organized.
every few days and delete whatever photos or videos we had there. Et en lui-même transmis cet ordre à ses propres subordonnés.
And he said that he had given these instructions to his own subordinates. But Myanmar doesn't stop at that. Over and beyond the destruction of evidence, Myanmar also fabricated evidence. That's Captain Naimyo Tet and former police captain Mo Yan Ning stated that the security personnel had staged facts by laying machetes next to Rohingya bodies and taking photos to give the impression that they were ARSA insurgents. According to witness P5513 of the IIMM, whose statement you'll find under Type 8, one of the bodies which he had initially photographed when it was prone was then moved by soldiers, and 25 minutes later, under instructions of the deputy commander, the same body was photographed, but this time round with an IED positioned next to it, and this was clearly an illustration of a deception and staging. Moreover, the same witness states
Tacit approval by their commanders, because when they reported the burning down of villages, commanders did not ask why or question their actions. Il mentionne également que les rapports.
They also indicated that the reports of ARSA, according to which ARSA had burnt villages of Sin Opin, were neither factual nor correct, and that it was the 562 Light Infantry Battalion that allegedly did so.
Ces témoignages sont aussi corroborés par des images satellites.
Finally, these testimonies are confirmed by satellite imagery. According to the fact-finding mission, hundreds of villages were destroyed and bulldozed, as shown by satellite imagery of August 2017 up to March 2018. The mechanism found that geospatial analysis conducted by UNISAT documents the extensive and sustained destruction of Rohingya villages in northern Rakhine State during and following the 2017 clearance operations. I will be returning to this shortly. Mr. President, members of the court, it is not only during the clearance operations themselves that Myanmar deployed efforts to erase the traces of its crimes, but also after those operations, with a view to completing on-site the eradication of the Rohingya people. This will be my second point. As the UN mission found, civilian authorities supervised, after the carrying out of genocidal violence, the bulldozing of burnt Rohingya villages, which were then replaced by the building of police facilities, border police facilities, and other security infrastructures. This was pointed out by Mr. Lowenstein yesterday. This was the case in Maodong Township, in Maungnu, Kangkya, and Indin, and in the Bujidang Township in Hong Taipin. What's more, the land farmed by killed Rohingyas or Rohingya who had fled were reassigned to non-Rohingya for whom housing was built, as well as roads and military facilities. The UN mission underlined that beyond the fact that they are clearly discriminatory in nature, these measures amount to a deliberate and concerted attempt to obstruct justice, breaching the obligation to carry out prompt, independent, and impartial investigations, and that they contributed to making the criminal landscape unrecognizable. These findings are confirmed by eyewitness testimony of BBC journalist Jonathan Head and the testimonies heard by the UN mission, documenting the building on the ruins of Rohingya hamlets of police stations and secured enclosures, including in the Mongdo Township in Myo Tuki and in Indin, as well as the building of fenced reception centres in Myazin in the same township. Amnesty International also told from November 2017 of a vast set of clearing works and then the building of state buildings on Rohingya buildings. This includes model villages, Natala villages, and security posts after the demolition of intact buildings and uprooting of vegetation. The UN mission documented the confiscation of tens of millions of hectares of Rohingya land via state programs. That is the Union Enterprise for Humanitarian Assistance, Resettlement and Development in Rakhine, and the amendments to the law on vacant, fallow or virgin land, facilitating the distribution of Rohingya land to other groups or their repurposing for military purposes. Some of these facts were made known to the court during the hearing on provisional measures in December 2019 and led the court to rule that Myanmar, and I quote, shall take effective measures to prevent the destruction and ensure the preservation of evidence related to allegations of acts within the scope of Article 2 of the Convention on the Prevention and Punishment of the Crime of Genocide. It is evident that the order of the court cannot erase destruction that took place before the 23rd of January 2020. But despite this order, the burning of Rohingya villages with a view to erasing evidence did not stop. The High Commissioner for Human Rights told on the 30th of June 2020 of large-scale fires in May 2020 in Bujidang Township, as seen by eyewitnesses and confirmed by satellite imageries, showing that areas where up to a dozen Rohingya villages once stood lay in ashes. The High Commissioner underlined that those were not only homes, but also constituted evidence of what happened in 2017, calling for immediate preservation measures. Members of the court, in its rejoinder, Myanmar alleges that its own inquiry showed no visible evidence of burned villages in Bujidang Township was found for the alleged time period. But Myanmar statements are self-serving, not verified by an independent source, and I would recall Myanmar refused access to its territory for any independent inquiry. The UN Special Rapporteur on the human rights situation in Myanmar pointed out in September 2020 that a new military infrastructure had been built on the land where Rohingya villages once stood. In September 2020, the IIMM published a report that you will find at tab 7 of your file, pointing out that despite the court's order, Myanmar had carried out a policy of systematic demolition and alteration of the sites concerned. According to the mechanisms of inquiry, the conversion of Rohingya villages from Ale Tan Cho in the south to Tongpyo Le Toa in the north of Mangdor, the conversion into bases for border police, combined with large-scale bulldozing and levelling operations, transformed crime scenes into sterile land, erasing essential markers to any forensic inquiry and for restitution, and making the collection of evidence on site impossible. To quote the mechanism, and I quote,
Rohingya villages and construction of BGP battalion bases on these sites has destroyed or permanently concealed much evidence of what occurred during the 2017 clearance operations. Le mécanisme a conclu.
The mechanism concluded that this strategy removed or destroyed crucial categories of evidence: mass graves and human remains, burned buildings, personal belongings allowing for victims to be identified and for modus operandi to be put together, ballistic clues, traces of explosives and weapons, documents relating to property ownership and allowing the targeting of victims, as well as links between command and on-site implementation. By fundamentally altering the scenes of these crimes, of its crimes, and by covering mosques, cemeteries, madrasas, which are religious schools, dwellings with security infrastructure, Myanmar spared no effort in hiding the truth. In this regard, successive satellite imagery of the same places taken over time show undeniably that these efforts were carried out to hide things. The UNOSAT's analysis found that on many sites that were partially or totally destroyed by fires started by the Tatmadaw, the land had been cleared of vegetation and leveled, and state facilities had been built. To mention one example, the satellite image you see on screen shows that in several Mangdor Township Rohingya villages, there was widespread destruction. That which happened up until November 2018 appears in yellow, whereas that which happened between November 2018 and April 2019, that is to say, after the clearance operations appear in red. The ASELI project is a collection of interactive geospatial data which compiles open source evidence and was developed in collaboration with the Center for Advanced Studies. It has found at least 44 sites where new construction has taken place since 2018, or took place in 2018, on the site of former Rohingya villages, burned to the ground. A pattern which the NGO sums up in the following terms, which sum up Myanmar's intention: burn, destroy, erase.
Un effort, pour rendre le...
And which is consistent with an effort to render much of the landscape unrecognizable. This data confirms that the disappearance of buildings and vegetation, followed by the building of police and military facilities and model villages, are part of a systemic effort aiming to reshape the area where Rohingya people lived so as to erase any evidence of the mass killings and prevent survivors from ever returning.
This is clear on the satellite images you are being shown. You see villages burnt and then new buildings. The first example relates to Indin village in Mongdo Township. Between January and February 2018, as the images show, villages were burnt down while new constructions were being built at the same time. Second example, Chenkali village, Kotankok in Ratadong townships in March 2019, where you see a similar pattern. Third example, Gudapin village in Butidong township in 2020, where things went the same way. Lastly, Kankia in Mongdo township. This highlights the same sequence of acts: burning followed by new constructions. We have here only a few examples taken from the UN mission. My third point, Mr. President, is that by preventing any access to its territory, Myanmar in fact facilitated the destruction and erasure of evidence, despite repeated calls by UN bodies and despite the obligations of preservation in the order of the court. Mr. Reichler mentioned it last Monday, and this is a fact. Myanmar hides behind its sovereignty and behind the lack of obligation to cooperate with UN bodies, but this obstructionist behavior clearly shows that Myanmar has something to hide. Despite the court's order, which, as I said, called on Myanmar to take effective measures to prevent destruction and ensure the preservation of evidence, the respondent continuously refused to grant access to its territory to the UN or any other independent mechanism, and argued that the Genocide Convention imposed no obligation to cooperate on it. However, hindering investigation while razing villages and building military and police buildings on the cream sign, it is incompatible with the implementation in good faith of the order to preserve evidence. Ladies and gentlemen of the court, this brings me to my fourth point. Despite the many pieces of evidence that I have mentioned, Myanmar denies its own practice of evidence destruction. It argues that Gambia submits no evidence of the specific circumstances of the burnings, and adds that attributing these facts to its armed forces is not established. But the alternative explanation, that is that the Rohingya themselves had burnt down their villages, is all the more disgraceful as it is false. In fact, you only have to look at the public reports and the testimony of BBC journalist Jonathan Head, which clearly states and shows that the photos supposedly showing Rohingyas burning down their houses have, in fact, been staged by the Tatmadaw, as Mr. Suleiman said on Monday. Moreover, Myanmar gives no credible evidence to support this surprising argument. Myanmar also relies on self-serving statements of ARSA prisoners locked up in the notorious Butidong prison, who have a good reason to sign anything the jailers will ask them to, as Mrs. Ho said yesterday. Now, caught red-handed because of satellite images, Myanmar does not deny bulldozers was used to clear out burnt-down Rohingya villages, but it is saying with great cynicism that it was preparing facilities for the repatriation. But what repatriation are we talking about? Repatriation towards military and police facilities built over the villages? The actions of Myanmar, as documented by UN bodies, contradict what Myanmar says. The UN fact-finding mission, through its in-depth investigation, clearly indicates that Myanmar is involved in a deliberate and concerted attempt to obstruct justice. Ladies and gentlemen of the court, it is improper to mix falsehood and truth, or even to hide truth knowingly. Destroying evidence is not a collateral damage of clearance operations. It is a deliberate practice aimed at hindering justice and erasing historic facts. This organized, cruel, meticulous, systematic destruction can only be understood as an indicator of guilt. As in matters related to genocide, this common sense conclusion is supported by the International Criminal Tribunal for the former Yugoslavia's jurisprudence, according to which destruction and concealment of bodies is a strong indicator of an intent to destroy the group. The convergence of facts duly established in our case can lead to no other reasonable inference. Let me thank you, honourable judges, for your kind attention. Can I request, Mr. President, that you call Professor Dargent to the podium, maybe after a pause if you feel that is relevant. I think Ms. Alamin.
The floor to the next speaker. The court will observe a break of 15 minutes. The sitting is suspended.